Thanis. I've been appointed by the City of St. Pete Beach to serve as the special magistrate for the case involving District Holdings, LLC. This is a resumption of a hearing that began in July. I see Mr. Kestenbaum, correct, is present, as well as Ms. Stuparich on behalf of the city and various city staff members. Mr. Kestenbaum, anybody else coming from your side?
Yeah, the current owners of the property should be here. I was texting with them a few minutes ago. I'm not quite sure where they are. If we could give them maybe a minute or two. I'm just gonna see if I can.
Are they in town?
Yes, they are.
Let's give them a couple minutes then. Good morning. All right. I know. Good morning, sir. And if you could state your name for the record again.
I'm the owner.
Okay. All right. We started and again, we've already opened up the hearing, and we waited a few minutes to make sure you were here. I'm assuming your partner's on his way?
No, I actually took a flight specially.
Okay.
To be here.
All right. All right. We are resuming the hearing that was started on July 13th. I'll turn it over to Ms. Stuparich. Anything you want to report to me from anything that's gone on since the last meeting?
Yes, I'll just make a few opening comments and allow the property owner and Mr. Kesselbaum, are you an attorney? Are you representing them as an attorney or?
I'm not representing them as an attorney. I'm here in my own capacity.
In your own capacity, okay. And Your Honor, I'm not sure if everybody who's giving testimony has been sworn in. I think perhaps the property owner, you were sworn in at the last meeting.
So we'll show for the record that anyone who was sworn in at the last hearing will continue to be under oath. If anybody new is going to be testifying, then we'll swear that person or
Chris,
people.
I don't know if you were here last time. So Chris Rosinski, he is our deputy building official. And Joe, I think you were sworn in last time. And Pete, you were sworn in, so.
All right, Mr. Rosinski, is it? All right, if you could be sworn in. Do you swear or affirm that the testimony you are going to give today will be the truth?
I do.
Okay. We'll show everyone who's going to be testifying, if anyone, has been sworn in. Ms. Stuparich.
Thank you, Your Honor. Okay, so at our last hearing, which was held in July 13th of this year, we had two matters before you. One was a status update regarding one of your prior orders, and also a separate action, which was requesting your authorization to foreclose on the lien due to non-payment and the failure of the property to be in compliance. So today we have testimony from our building official and our permit technician who will bring you up to speed as far as the city's records of what has transpired on the property, as far as bringing it into compliance for the failure to have building permits. We'll also offer testimony from Pete Dwar, who will advise you as to the status of the receipt of any monies from the town and just other information that we may have regarding this situation. At the conclusion of their presentation, whatever Your Honor chooses to do, we would then ask for the authorization. I don't know if you want to split them or if you want us to go ahead and do that presentation.
You're asking about the authorization to pursue foreclosure of the lien?
Correct.
Okay, all right.
So it's for, you want to hear our opinion first and then decide?
I'll certainly give you a chance to speak, and we're probably going to go ahead and, well, we'll have the city go first, and then you'll have an opportunity to give me an update as to where you are.
Okay, very good. So the primary issue is really bringing the property into compliance. That is the main goal and intent of the city moving forward with this matter. In that regard, I would like to go ahead and call Chris Rosinski to give you information and testify as to the status of the pending building permit. Yeah.
Come up to the podium, please. It's yours. Go ahead. Unless Ms. Stuppers is going to ask you direct questions, you can go
No.
ahead and...
Basically, just give him the summary that you have provided with me and Mr. Duar regarding the status.
We did a site walkthrough with the contractor yesterday to see the status of the property, and it's in a semi-demoed state. No repairs have taken place except for some fire sprinkler piping.
Could you explain what semi-demo state means?
Yeah, the floors of individual units are chopped out. It's pulled back down to bare walls. Some of the sewer lines have been removed and excavated, and no replacements have taken place.
And the proposed demolition is for the interior or the exterior?
Interior of the building.
And what's the status of permits on the project?
It's permitted. They've called 6 inspections to date.
I'm sorry, could you repeat that?
It's permitted. They've called 6 inspections to date.
Called 6, explain to me what you mean by...
It means they've called in to have inspections done on the property from the building department 6 times so far.
When was the last time that there was a request for an inspection?
Yesterday.
Could you add when the first inspection call was? Were these, the 6 that you've referenced, is that in the recent past, or is that go back for?
No, that goes back historically to when the permit was pulled originally.
Could you give the magistrate the dates? Do you have those?
I don't have that. Joe does.
So maybe if we could call Ms. Bolin, or she has the dates, I believe.
All right.
Good morning.
Good morning.
Okay, first inspection was called in on May 16th, 2024, performed on May 17th, and it failed. It was for building windows and doors. There were no product approvals or permit placards on site.
Can you please mention who was the owner, because we were the owner then?
Yeah, so
the
I
se-
understand the ownership situation. You are the owner now. Mr. Kestenbaum was the owner previously when this case was first heard in 2022, and that there was a subsequent sale that was made after the order the first order in February of 22 was entered. I do understand all of that. Go ahead.
Thank you.
Yep.
Second inspection was on 5/21/24 for windows and doors. And that was passed by Brian Reed, one of the inspectors. Third inspection, building framing. That was done on October 6th, 2025, partial pass. Electrical temp pole, 10/27/25, that passed. There was attempt to permanent power inspection. Yehovah, the contractor, said that that was not supposed to be on this one, and that was canceled. And then since 10/27/25, there was an inspection on the 24th for a job site status meeting with Chris Rosinski, our deputy building official, for plumbing underground and building framing. And there's another inspection on here, but it was an underground visual for another permit by the fire marshal, which was performed yesterday as well.
So is it your testimony that there are still open permits?
There's, this is an open permit, and there's inspections that need to be
Completed?
completed, a lot of inspections that need to be completed.
Is it
Yes.
good?
Mr. Tanis, is asking Deputy Building Official Rosinski, is the property close to being completed?
It is not. It's not even completely demoed at this point.
So you're stating for the record that the property is still in the demolition stage on the interior of those units and is nowhere near completion?
Correct.
And the permit was issued when, please? Ms. Boland?
Permit was issued, one moment, please.
Seven 31/23.
Yes, July 31st, 2023, building permit issued.
And they've had 5 inspections, if my calculations were correct, and maybe there were maybe 1 or 2 off. But since 2023, they've had 5 inspections, and we just heard from the deputy building official that they're nowhere near completion. As a matter of fact, the property is still in the pre-demolition stage on the interior of the units.
So, Mr. Dwar, then based on your conversations that you've had with your building officials, it is your opinion then the property remains out of compliance with code? Is that correct?
Yes, that is correct. And I have pictures that were taken this morning of the state and condition of the property.
Since we've kind of delved into Mr. Dwar's testimony already, could you go ahead and testify as to whether or not there's been any payment made regarding this particular lien? And your research that you've done.
Thank you, Ms. Stuparich. Mr. Tanis, Pete Dewar, Code Enforcement Manager for the City of St. Pete Beach. The recent research that we did and the pictures that were taken.
First of all, has there
yes.
been any payment made?
No payments have been made to the city,
Thank
Ms. Stuparich. Thank you. As a matter of fact, would you like to ask me about the certificates or the pictures?
Justified.
Okay. The research that we have found, Mr. Special Magistrate, indicate that there are 2 certificates that were placed on this property, one in 2024 and the other in 2025.
And the basis for, so those are tax certificates, they are not tax deeds, is that correct?
Those
So
are tax certificates.
Ownership has not changed, is that?
Ownership has not changed. Here's the warranty deed proving that the owner is still KOA, Capital Partners, Florida LLC. Those tax certificates signify that the property has not paid up their taxes. I don't think their taxes have been paid for 2025 either.
I think if you go back to your documents, you can show,
There's the tax bill,
for which year is that?
2025,
And the other one?
2024.
Okay, but there has been no deed, tax deed changing ownership, is that correct?
No, that's correct.
Okay.
As we stand here today, the fines equal to $371,250 without administrative costs, and that is just the lien amount as was calculated. Here's the condition of the property, and like we just heard from the deputy building official, they're still in the pre-demolition stage.
Mr. Dewar, you just showed a warranty deed. What's the date of that deed? I just saw it on the screen. It was on briefly.
There it is
Yeah.
again.
And the date of that deed is
Could
that
we zoom
April
in?
8th, 2022?
Could we zoom in, Ryan? April 8th, 2022. is when the.
Okay, thank
Yes,
you.
sir. And these photographs are a true and accurate representation of the dates they were taken this morning. And this is the exterior portion of the property, curtilage around the property. It's clearly not being maintained.
What's not making, just personal?
These
Could you go back to the photo, could you go back to the photo that you just had up there? Take that one off. All right, so I see two distinct buildings. One is the two-story white building that looks like it's under renovation, correct?
Yes, sir.
All right.
It's
and-
all part of the same parcel.
And then the parcel with the plywood that's, looks like half faded at the bottom, is that part of that same complex?
Yes, sir.
550
Corey
Corey?
Avenue, all one.
All under single ownership?
Yes, sir.
Okay.
Your Honor,
Close-up showing. I'm
we-
sorry, go ahead, Nancy.
the purpose of taking the photographs, we wanted to verify that there was actually ownership, that there has been no change in ownership. Our concern is that there are for sale signs.
And as Ms. Duperich alluded to, here's the for sale sign saying it's available. That's a wide-angle view of the same property. This is all 550 Corey Avenue from...
Did you took it from the inside as well, or just this section?
Sir, it's not your turn. Please don't continue yelling from the gallery.
It's used, you know.
Yeah, you have a chance, sir. You'll have a chance to ask questions, and you have a chance to make statements.
This is, from here to here is the same property, 550 Corey Avenue, that entire area. Wide angle. This is closer to the front of the property. This is the front of the property as you look towards, and again, it goes from one end to the other. And so this is the front where there's an empty pool right there, and there's overgrowth.
So
As-
those are additional residential units that, I'm seeing the single-story structure. Those are additional residential units that are part of the complex. Is that correct?
That's correct, yes. And the question was asked, I guess, of us going inside the property. As you see, there's a gate there. There's no reason for code enforcement to go inside of the property. We have a building official who is able to do that, and he testified that the property is still in its pre-demolition stage. So, thank you.
Thank you.
Your Honor, we'd like to share those documents with the property owner and Mr. Kesselbaum, and then have them request that you accept them into the record.
All right.
May I say something?
Sure. Let's let the city finish first. And Ms. Duperich, anything else that you'd like for me to hear this morning?
Not at this time, Your Honor. I
right.
just want to make sure they have an opportunity to review those photographs and documents.
All right. Mr.
Ben Abraham, yeah. I'll do it quick.
Mr. Diane, Mr. Abraham, and Mr. Kestenbaum all have an opportunity to ask questions of the three city employees who testified this morning. Do you have any questions of them, or do you want to go ahead and just make a statement?
I'll make a statement with some questions during, so it's going to be related. If
Go ahead and identify yourself for the
Owner
record.
Ben Abraham. I'm a co-owner, currently co-owner, KO Capital Partners, Florida.
All right.
All right, I'll do it quick. Most of the things that the gentleman and the lady mentioned already, we've been here, we know all that. I think it's a waste of time. No disrespect. You just mentioned things that we already know. A month ago, we had this conversation. Just for the record, 2024 taxes paid in full. You can check it out. 2025 is not due yet. If it's an urgency, we can pay it tomorrow or today, just for the record. It's been, I think, a month-ish since we spoke. We already had a Zoom call with the lady, and I don't remember who, but we have it recorded with permission, of course. And we asked about, hey, what's the next steps for us? It took us 10 days just for you to know to have this conversation. We spoke about the city. 10 days to have a Zoom call 10 days. Yeah. Lucky that you, sir, told them that they're not going to charge us a penny until we have this, until he has today's hearing. 10 days, just for the record, multiple 10 days by $250. Who is paying that? Yeah. Lucky that no one is, but just for you to know. So in this conversation, we agreed that we show progress, we'll show everything, and I can tell you that we had 4 inspections scheduled. 4 inspections, fire protection. Of course, I'll let Anthony speak. He's the GC, he knows. You guys been in the field, you know, 4 inspections since then. Okay, so that's for the record. Second thing, a little bit misleading, I think, over here. No one can finish this project in a month, especially when it's 10 days. It took you guys 10 days to reply. So 20 days to finish this project, I don't think it's doable. It's kind of showing a picture in a wrong angle. That's that. We want to mention also that we got a CO for 600 Corey, as we promised. So right now we kind of over-delivered, which we're happy. Yeah, we got a CO. We got 4 inspections since then. We are in a run. Taxes got paid. Again, you want 2025? We'll do that as well. Right at the moment, we're on the run. One more thing, a few more things that I want to mention. Pictures. What do we see in these pictures? Grass that wasn't cut. We did it before. We can make it happen. This doesn't say anything about the property. One more thing, you mentioned something about a sign. I don't see how it's a crime to have a sign for sale. I think it's actually helped us out, and you guys as well. As soon as we can list it, we can have people there. We can schedule people there to get them inside, and it's going to help both fill the property with tenants and also help sell it, because it's going to be a turnkey for the next buyer. Okay, so we have that as well. One more thing. We have, of course, as you guys, pictures and videos from any angle of this property. The only section that wasn't painted is the section that this gentleman showed you guys. Again, if you want to show something, show the whole picture, not only the wrong thing. You can say, hey, everything is painted, everything is have stucco, everything is 1, 2, 3, and 4. Only this section doesn't have it. So just for the record, of course, you guys are more than welcome to see the whole thing. Gate, you mentioned a gate. You have an entrance on the right-hand side. You can enter there. You don't have to jump. You don't have to do anything. Go ahead and do that. You have it there. And one more thing I want to say. Okay, I'll sum it up just to make it short. Since our conversation, which was roughly a month ago, we had a conversation with the city after 10 days. So we left with 20 days. In 20 days, we got a CO, we got 4 inspections done, and we are ready to move to the next step. I'll let Anthony speak about the rest, but I think in 20 days to get all this done, even if it's partial passed, even if it's partial, whatever it is, 20 days, guys. We got a CO and 4 inspections. I think that Superman can do that.
The CO you're referencing is for 600.
Yes, sir, correct.
So you made progress there. You're saying because you made progress on 600 Corey, now you're turning your attention to 550 Corey, and you can make the same kind of.
Yes, sir, that's correct. We mentioned that last time. We said that we're going to shift all the manpower from 600 to 550 once it's done, and we made it. We delivered. We made 125% of, I'm thinking, over-delivering. We made all of that in 20 days, sir. So if this doesn't mention, if this doesn't say something about our progress, I don't know what is. 4 inspection and a CO in 20 days. I think it shows that we are serious. It shows that we got the city attention. We got your attention, sir. And we want to come here to this hearing and to tell you guys, hey, I'm happy to stand here. I'm proud to be here, and to just say, hey guys, We made it. No matter if it's a grass that wasn't cut, of course we're gonna take care of it, yeah. But to show that it's a pre-demo, we know it. Like, what's the news? That it's pre-demo? Like, we know. You want to show a progress for inspection and CO.
What's the status of your contractor? You had it,
I'll let him speak by himself if you don't mind. I want to mention one more thing that regardless, I want, sir, if you don't mind, to check the red tag thing and the whole penalty thing. If I recall, the red tags for the electrical, sorry, it was belonged to the, regarding to electrical. We did that many years ago. So I can't find, and I'm not a lawyer, I'm not an attorney, I'm just saying it. I can't find a reason for someone to keep penalized for red tags, even though this issue was solved how many years ago. It's kind of, you want to request money for something you don't deserve. Again, whatever city needs, we're here to deliver, as we did it so far. Anything that you need, be reasonable, please. We all want to work together. You don't expect this project to finish in 20 days. No one is. It's a 14 unit building. Everything is scheduled. We have the Gantt. We have everything. You guys, as I told you last time, you tell us what's needed to be done. We'll make it happen. Be reasonable. Work with us. We'll be happy to deliver.
do you feel that the city needs to tell you what needs to be done, or do you and your contractor know what needs to be done?
I want the city to tell the truth. I want the city to not try to fail us. We work together. You want your money? Fine. That's something that, everyone wants money. But don't charge us because we are not like an institution or something like that. We're here to work with you. Don't steal from our pockets. I'm not saying that you're a thief, but don't steal from our pockets because you can. Don't use your power like that. It's not ethical. I think it's something that it's wrong.
All right.
I just want the city
point.
to tell us what they want. We will deliver as we delivered right now.
Thank you.
Thank you.
All right. I know you, come on up, sir. You're the contractor on the, and your name again, please?
Anthony Babick.
Anthony, okay. And you were here for the last hearing?
Yes, sir.
You were sworn in
Yes, sir.
at that hearing? You're still under oath?
Yes, sir.
You've obviously maintained your relationship with the current owners. You're still working for them, and you have a contract then to complete the building? Is that correct? All right. And what's the timetable for completing the building?
Me and Chris had a discussion about that yesterday. He thinks it's over a year. I think it's going to be under.
I'm sorry, say that again?
Less than a year.
Okay.
Yeah, I mean, we have an aggressive plan. And just to be full transparency, again, as I mentioned last time, I had the contract to both buildings, so I wasn't necessarily looking at this as two different. I didn't fully understand that there was additional stuff outside of construction in play here. So when we kind of moved everything to 600, got that all the way done, so then that way we could get everything back to 550. We did schedule a bunch of inspections. We had the underground fire. I was trying to get the grass kind of all, the ground kind of closed up. So we've been working with Kelly. We got the visual, which is true. There was a problem that we had with on the city side that we had to do a repair to get it fixed. So there is progress that's taking place. As far as like the grass being grown, I mean, we just had everything weed whacked and sprayed. I think the guys were just here yesterday or the day before spraying for weeds. So it's not a matter of no progress being done. Again, from my perspective as a builder, I was kind of trying to get 600 done and then moving everything to 550. I mean, I have the subs ready to go, and the guys are already in sequence to come. I think there's also some other things that need to be said. The first thing is, obviously, there was 2 hurricanes that took place. There was not intentional, but there was downtime in this project where things didn't move. There was a violation that we had to go back and reclassify what the building was, if it was a level 1 alteration or level 3, where no project progress could take place. So there's been a bunch of delays, force majeure, that were baked into this that kind of. But it is true. There's been a long time from when we scheduled the first inspection to now. We've worked through all of those, and I'm only talking about like the building, lane in this whole situation. I was working on this project before 2 building officials ago when Rick Dunn was here, and then Mark. You know, these guys have been great. I mean, I don't have anything, Chris and Luke have been amazing. We did have the meeting like on the Zoom like 2 weeks ago where we kind of ran through everything. I don't think that there's a matter of not trying to get the project moving and going. Like I said, there was just getting 600 finished, completed, so that way everything can reconcile, and then they were able to go full force on 550.
Okay. Thank you. Any questions for the contractor?
I don't have any questions. I don't know, Pete, if you wanted to.
Okay.
No.
Thank you.
Thank you.
Mr. Kestenbaum, come on up.
I think it would be useful. I think I heard you say.
The mic.
Yeah, come up a little closer to the microphone so we can keep everything on the record.
Anthony, I think I heard you say a couple of minutes ago that, was it this gentleman right here? Is it a realistic timetable to actually complete the building is like a year?
Over here? Was that what we said?
Year and a half.
Oh, year and a half.
So you've got, and I just want to make sure I'm understanding this correctly. You got your city employees saying it should take a year and a half to complete this building. Mr. Dwar, I think I heard you stand up here and it seemed to suggest that because in 30 days, substantial progress hadn't been made, you guys are asking to foreclose the code compliance lien when your own employers are saying it takes a year and a half. These guys are doing everything they can to get this project done. They met with you 2 weeks ago, 3 weeks ago, whatever it was. Is there anything you were expecting them to do in the last 2 or 3 weeks on this project or on this property that they haven't done? I'm not sure who that question's for because I don't really know.
I think it's more of a statement that you're making, Mr.
Fair enough.
And I understand your point. So
I don't
we're clear.
really know the
So we're clear.
process.
We've had 43 days since the first hearing and since the July 13th hearing and today. I understand it may have taken 10 days to get a Zoom call together, and that leaves 33 days to get something done. I think what I'm hearing is there's been some activity, including an inspection that took place yesterday, which is certainly good news because it shows me that things are moving forward. But I don't think any of us sat here on July 13th and expected the entire project to be done in 43 days.
Your Honor,
when we set this date.
we object to that and the representation that's been made. The city has been waiting since 2022 to have this property brought into compliance, and that's really all the city wants.
So
It wants
I'll overrule the
compliance.
objection. Mr. Kestenbaum is testifying, I think, and he's expressing his view of the case, his frustration, and I understand he's no longer the owner, but he has a monetary interest in this case, and that's why he was here in July, and that's why he's here today. I certainly understand that. I'm going to let them finish, and unless you have any questions of them, I'm not asking you to ask questions. I'm just saying if you'd like to ask a question, you certainly have that opportunity. Otherwise, Mr. Kestenbaum, if you want to finish your statement, go ahead.
I do, and I'm actually going to phrase it. It really is more of a statement. I'm going to phrase it as a question. I don't know who the question is for. Feel free to object to the question. I just heard you say that the city wants nothing but the property to be brought into compliance. Your own employees say that's going to take about a year and a half. Okay, fine. You have an ownership group who is here, ready, wanting to work with your staff to complete the project. We have they had their contractor here. They're ready to go. Why are we here? Why are you trying to foreclose? Why do you want to foreclose the lien if all you care about is getting the property into compliance? These are the guys that are trying to do it. Maybe it'll take a year and a half. No one else is going to be able to do it any faster. So what are we doing?
Your Honor,
Yeah,
if you'd
I
like
think it's
me
more of
to
a statement. I think it's
Okay.
more of a statement. You can answer that if you'd like in your closing, if you'd like to make a closing, not mandatory, because I understand what's going on. I'm going to let anybody else from the ownership group that want to make a statement. All three of you had a chance. Mr. Abraham, your last opportunity here to tell me anything you like.
Something small, we have multiple inspections.
Come on up. Yeah, I understand. Go ahead, sir. Final statement.
Again, we want to work with the city. We're here to work.
Don't repeat yourself, because I've heard,
That's all I said.
I heard that at the last hearing. I'm hearing that again today. that you-
Exactly. People, like most of us, repeat about the same thing again. We've been here all together. It's all recorded. You can go and search for that. I think that everyone says the right thing. I'm not going to repeat about that. One thing that I heard, which is I think is maybe I didn't hear right, we have multiple inspections since then. Multiple. Okay. Anything else? You guys tell us what to do, and we'll do it.
May I ask him a few questions?
Yes.
I guess, yeah.
Thank you. I think at the last hearing, you testified that there was no sale that was pending for the property, that you were not intending to sell it. Can you tell us when that sign was put up for the for sale sign?
I don't remember. I have to check it out. But it's my right, if I understand right, to do whatever I want with this property. My intention is to bring it to compliance, and then I have all the rights to.
Compliance and putting a for sale sign is different.
Why is that? What do you think?
I'm asking, when did you put the sign up?
I told you.
for sale?
You asked, I answered. I don't remember, have to check. Why is it so important to you?
Okay. You said, you've testified today that the taxes have been paid.
2024.
Did you see the document that we provided? Could you comment on that?
I didn't see. I would like to see it. If you need a proof.
We had offered, Your Honor.
Yeah, if you need a proof of 2024, it's online. I can search for it and send it to you today, yeah?
Tax certificate has been issued, so the taxes were paid by an investor. So the taxes are still basically
2024 paid in
2024 and
full.
2025. There are two tax certificates. We pulled the information.
Remember,
this morning.
read my lips. 2024 paid in
Would you
full.
look at the document, perhaps?
You might guess. Why not?
It's right, it's right.
2020, and I also told you. I remember what I said. I am standing behind my
If I
word.
could interject here.
Sure.
So whether the taxes were paid or not paid don't necessarily address the issue of what I have to decide under the ordinance.
Absolutely.
I think the city wanted to bring to my attention that there was either a delinquency or the delinquency still exists.
And
the
possibly not a change of ownership because of the issuance of a tax deed due to the payment, the non-payment of tax.
Well, I think the KAO Capital Partners Florida LLC has owned the property since April of '22 and continues to own it.
Right.
I don't believe there's been any tax sale
There
where
is
somebody
not.
else, right, so, and
We're good
you're saying
boys.
an investor may have paid, so you're saying that a third party may have interjected itself, paid the taxes to line itself up to acquire the property through a tax sale process.
But that process has not come to fruition yet.
And that's a fairly lengthy process anyway, correct?
I pay the taxes myself. How can I be? Like, I paid it. I have a proof.
All right, so,
The city wants. It's online.
yeah, I think what Mr. Dewar showed in his testimony was two certificates that showed the 24 and 25 taxes, and that showed the 25 taxes as not having been paid yet. I think at this point, if they are paid, if you have some evidence of that, then you feel a need to submit it, that's fine. Otherwise, I'm ready to make a decision today.
And I guess, my friend, whatever they want. You want 25 to be paid? I told you. I repeat about my statement. I'll pay it. No problem. 24 paid in full. You need 25, even though it's not due. It's gonna help you to feel more secure. No problem. We can do that as well.
All right.
Anything from
Ms. Stuprich, I'm sorry, your name again, ma'am? Your last name? Ms. Boland had her hand up. I don't know if you want her to say
She
anything.
probably would like to put some testimony into the record, so go ahead.
Yes.
Come on, please, yes.
You need from me or from someone else?
I just want to clarify that nothing has prevented them from doing work in the year 2026. As far as inspections, the last inspection that was performed was October 27th, 2025. The inspections yesterday were a site visit only. That's all it was, a site visit. The inspection from Kelly says clearly in here, underground visual for permit number 240-1483, which is a fire permit. It was not for this permit. So there have not been any completed inspections since October 27th, 2025. And no work has been performed in 2026.
Thank you. All right, let's try to wrap this up.
Mr. Dennis?
Yes, Mr. Dewar.
Before Ms. Duprich, what I'd like you to consider as you're making your decision is that this property was in the hands of District Holdings Florida LLC prior to it being sold to KO Capital. If you recall, sir, the sale of 550 Corey Avenue was contingent on the owners being able to renovate 550 Corey Avenue within 90 days as they presented to you back in 2023. And is why that money was held, that 86,000 was held in escrow. This has nothing to do, fast forward to today and us hearing about these inspections. I know, by the way, as Ms. Bolden just testified, there have been no inspections in 2026. We just paid a site visit to the property so that they can tell you that they had an inspection by our building official. For the record, and so you're aware, if we're doing the math, there have been less than 2 inspections since this property was sold to these new owners, KO Capital. So this idea that they are all of a sudden doing all this work, I think is just a facade. The point is, and the reason for us being here is that this money in escrow, 86,000, was held, determined by the fact that they were going to complete this project within the 90-day period that they themselves wanted to complete the project in, back in 2023. Has nothing to do with fast forwarding to today's date and the last several months of this action or activity that we are now hearing about. Thank you.
And to go into my closing, if I
Yeah,
can.
well, I'll tell you what, before you start your close, go ahead, Mr. In relation to what Mr. Dewar just said, go ahead, sir.
So it's not a facade. This is the way to work. I cannot do anything without that. This is a process that you guys mentioned. Also, you mentioned things that was prior to the previous hearing. How does it help? You bring something so we can kind of play with our minds. It doesn't help. We know the facts. It's recorded. We've been here in this hearing before, remember. It's all recorded. So we know the fact that you said 7 months ago or 2026 wasn't done. We know that. We spoke about it before. Right now, we're in a position to continue. You guys are keep mentioning things that happened in the past prior to the previous hearing. We know that. You're kind of trying to manipulate the system. We know that. We're right now going straight forward. We're not going back. So by saying that doesn't help. We want to know what's going on next. It's not a facade. This is the way we work. We're following instructions. 2026, we have multiple inspections. Part of it is to see it. If you guys want to say otherwise, be my guest. One more thing I want to mention. Again, I'm not a lawyer. You mentioned 90 days. 90 days for what? Red tags? Electrical red tags? Or bring it, the whole building to completion? I would like to check that. Again, I'm not an attorney, but it's something that I think you guys are leaning on and based on. I would like to check that. If it's a 90 days for red tags to be removed, I think we did it. I don't remember when. Should check, but I think if they're basing their case on this one, it's worth to check.
I would like to say one more thing.
Come on up to the podium, please.
Mr. Dewar, the notion that any work they are trying to do is a facade is an absurdly insulting statement. It infuriates me. No one expected that property to be done in 90 days. Your own employee just said it would take 1.5 years.
Your Honor, I think these are personal attacks.
Yeah, let Mr. Kestenbaum, you know what, I will allow Mr. Kestenbaum to testify. I understand there's some personal attacks that may be intended. I'm going to let him finish, though. So your point's well taken, though. But go ahead, Mr. Kestenbaum.
The $86,000 that is sitting in escrow is completely irrelevant to whether the city should be allowed to foreclose on a code compliance lien. The city is not a party to any agreements relating to that escrow. That escrow agreement is between my company, this gentleman's company, and the escrow agent.
Yeah, this is in the order. Yeah, it's in the order.
Once they get the property done, we will work with the city to resolve whatever financial payments need to be made to address the amount of the lien. The only thing that these gentlemen are doing now is trying to complete the property. They're ready to go. They've finished the other one. They're turning their attention to this one. There is no reason for the city to foreclose and take ownership of the property other than, I suspect the city probably wants to own the property. They would probably like to put something else there. Unfortunately, it's private property that's not owned by the city. And the city should simply cooperate with ownership to allow the work to be completed. It's going to take time, might take a year and a half, but it's going to get done. And I'll stop.
He's not the lawyer either.
All right.
Yeah.
Any other comments?
Again, just to clarify that the comments that were made in his individual capacity. He is not representing the current owners in any type of legal representation.
That is correct.
I understand that.
Thank you.
All right.
Your Honor, we're ready to make our closing comments.
Contractor wants to make one more statement. Sir, go ahead. I want to make sure, and again, I know this seems tedious to some people, but I want everyone to be able to leave here saying at least that we got to say what we wanted to say. And, sir.
Yeah, I just wanted to, I'm not disputing anything that the lady just said, but there are, in construction, multiple trade permits that get attached to it. So while technically it's on a different permit, you have to go in sequence. And we have to get all the underground stuff situated and closed up before you can move on to the next one. So I just want to make that, I guess, clarification.
I understand.
Thank you, sir.
There's a process, and not everything happens all at the same time, and that's why it takes a year or a year and a half to...
Well, I'm just saying, like, I look at it as it's a whole project. So whether it was a subcontractor traded thing, okay.
Thank you.
Okay, so Your Honor, at the beginning of the hearing today, I started off by saying that there were two items really before you. There are two items on the agenda. The first was the status hearing, and I think you've heard a multitude of testimony regarding what the status is from the various perspectives, from the city's perspective as well as the property owner and the prior property owner. I do want to point out the issue of the escrow. The only reason the issue of the escrow has come up is because it was reflected in your prior order of April the 11th of 2022 that was part of the history of 550 Corey Avenue as well as 600 Corey Avenue. So that money is available to be paid, to have the lien paid down, but not satisfied, because today there was testimony from Mr. Dewar regarding the outstanding amount, and that kind of dovetails us into the second item before you today, which is the authorization to foreclose. There's testimony made as well that the property is not in compliance. The lien that we are foreclosing on has been of record for more than 3 months, and under Florida law and our code, we have the ability to foreclose on a lien if it has remained unpaid. Again, by the testimony of Mr. Dewar, the lien has not been paid. More than 3 months have passed. So I think we've satisfied the minimum criteria that would allow you to enter an order allowing us to initiate the foreclosure proceeding. The city is going that route. The city does want compliance. I think there's been innuendo made that the city is out for a money grab. We are not. We are looking for compliance. There was also testimony at the prior hearing of reduce the amount of the lien, reduce the amount of the lien. That is a separate process that is available. However, the property has to come into compliance before any reduction of the lien can be determined. So again, just for whatever it's worth, this property is in not only is it subject to recovery from the storms, but it's also in a redevelopment area that's part of the downtown. So the city does want this property to come into compliance. What is it going to take? Well, since 2022, nothing has really happened as far as bringing the property into compliance based on the agreement that was made before Your Honor that this property would come into compliance. The only reason that any activity has occurred is because the city brought this matter before you in July. And so for that reason, too, we feel that it's very necessary. Not only have we satisfied the criteria to authorize the foreclosure, but this is the only way that this property is going to end up coming into compliance. Now, with your authorization, we will basically proceed with the foreclosure. There is nothing that inhibits them from coming into compliance, from working very quickly. Once the compliance is achieved, they still have the opportunity to come before you and ask for a reduction of the lien. But without further action by Your Honor, we don't see any movement being made on this property.
Turn to Mr. Kestenbaum. Anything in addition to what you've already stated?
I would just repeat the things that have already been said, that
No need to repeat. I understand.
that was
I understand.
that was nonsensical.
All right.
That's
Thank you. And Mr. Ibrahim, you stand on everything you've stated. Okay. If I'll have a written decision for everyone, but let me just tell you what my decision will be. So if this were a new case coming in the door now, let's say it started July 13th, I would certainly provide the owners with an opportunity to go through a renovation process. I am not a contractor, but I've been around construction projects enough in my 47 years of being a lawyer to know that it takes a while. And in order to for that to happen, certain things have to happen, and the contractor testified you don't wave a magic wand and everything happens at the same time. Certain things have to happen in a certain sequence. But this is not a new case. This is a case that started before me in February of 22. Mr. Kestenbaum was the owner at that time. He was in a position to sell the property. I understand he's out-of-state resident, and there's a lot of out-of-state residents in Florida who invested in property and have done well, some that haven't done so well. In this particular case, I certainly understand Mr. Kestenbaum ran into a pandemic that we had not seen in over a century that may have affected his ability to make progress on rehabbing the property. He was, from his perspective, fortunate to find KAO Capital Partners Florida LLC, two people who are the principals of that, to step in while a case is pending and being willing to purchase the property while a code enforcement action was pending against it. Mr. Kestenbaum was not here in 22. I think it was Mr. Johnson or Johnston who appeared as the property manager in February when the case, and at that time it was a new case, and I said, let's give this some time, tell me what the plan is, come back in 2 months and let me know where we stand. And what the result was, a sale took place a few days before the hearing, and I was informed that the new owners were going to proceed with a renovation of the property, and that money would be put in escrow to show good faith and to provide some kind of guarantee that the work would proceed. That was April of 22. No one from the respondents, whether it's Mr. Kestenbaum or the new owners, appeared at that hearing. I took the then city attorney, Mr. McConnell, I believe it was, at his word. He represented it to me. He's an officer of the court. He's obligated to provide information to me that's accurate, and I had no reason to doubt the veracity of what he was telling me. I entered an order based on those statements without anyone from the ownership side being present to say that's not our agreement. We then proceeded for a 2-year period. I had no involvement. I don't know what was going on at that point. Then we had another calamity occur, and that would have been in September of 2024 with 2 hurricanes that this area had not seen the damage and destruction in probably a century, if not longer, which obviously had an impact on the ability of the new owners and the contractor to complete the work. I understand all of that. But there was a 2-year period there where, from my perspective, in looking at the property and hearing the testimony today, it appears not a lot of activity went on at 550 Corey. It may have gone on at 600 Corey, but there was not a lot of construction activity going on at 550 Corey. Since then, going back to June of 26, that's when the city resurrected the case before me, asked me to step in and enter an order authorizing a foreclosure. We spent a lot of time at the last hearing going back and forth about what could be done and what could not be done and what time periods would need to be provided. But my hope was that there would be some meeting of the minds where the contractors would come in, meet with the city staff, and come up with a plan that would convince everyone that you are ready to complete the work within a certain period of time and satisfy the city. I will say the presence of a for sale sign has nothing to do with my decision. The status of the taxes, while it is important as far as showing the responsibility of a property owner and the financial stability of a property owner, those are important issues, but that's not going into, it's not a factor in my decision. My decision is based on what was decided previously. So fast forward 4.5 years later, here we are, and while there has been some progress made, it does not appear to be anywhere near completion. I understand the owners need more time, but my order, I'm being asked to make a decision based on whether the city can move forward. Under the ordinance that the city operates, and that's what I have to follow, the city is entitled to an order authorizing foreclosure. Foreclosure is not automatic. It still gives the property owners time to work with the city in getting the property rehabilitated to a point where they may be able to stave off foreclosure. It's going to be a business decision the two partners are going to have to make as to what kind of time and money they're going to invest in the property, and it'll be up to the city to move the case along as it sees fit. Foreclosure actions don't necessarily move with lightning speed in state court, so there may be some time to get work done and be able to avoid the actual ultimate foreclosure. I think I spent a lot of time at the last hearing in July concerned about the $350,000 or $360,000 in fines that have accrued, and I think everyone in the room understood I was probably not leaning to reaffirming the full amount of the fine if the property was brought into compliance. Ms. Stuprich is correct. I can't reduce the fine right now. The city ordinance, and for anyone who wants to read it, it's 22-283, has certain criteria that must be met before I can reduce the fine. I would reduce the fine based on a Supreme Court case from 2019, Timms versus the state of Indiana. The state of Indiana sought a forfeiture of a it's a British make. I don't recall. What's the British vehicle? I can't. Anyway, the type of vehicle, the Land Rover. They had a $10,000 penalty against Mr. Timms, the defendant, and they've tried to forfeit a $42,000 Land Rover that he had owned because it was used during the commission of the crime. He was selling some heroin to feed his drug habit. And the U.S. Supreme Court, in a unanimous decision, which I think those of you who follow the Supreme Court over the past few years, it's very rare that they have a unanimous decision, said that the action of the state of Indiana was disproportionate and was an excessive fine, and they would not allow the state to enforce the forfeiture of a $42,000 vehicle to satisfy a $10,000 penalty. There is state of Florida case law since Timms and before Timms that indicates that the amount of the fine has to be proportionate to the offense that has occurred. But I'm just telling you now, I'm not authorized by the state statute that controls code enforcement hearings or the local ordinance of St. Pete Beach to reduce that fine at this point. If we were at that point where you had the property in full compliance, I would be inclined to reduce the fine substantially. There's an issue as far as this escrow money that's being held. Frankly, that's something that Mr. Kestenbaum needs to deal with, the escrow the title company holding that money, and what your agreement is, your private agreement. I'm not a party to that agreement. The city's not a party to that agreement. I don't have the authority to order a title company to pay it. At least I don't think I do. I may, but at this point I haven't been asked to do that. But my position is that the city has provided a status. The status of the property is that it's still out of compliance. I think if you drive by the property, you will see that it's out of compliance. Since our July 13th hearing, it doesn't look like there's been a lot of work just to at least tidy up the outside of the property and what shows from the street. While you have done some work, I'm sure, on the inside, case like this, if it were my property, I would have done some work on the outside to at least make the outside look better. The city has an obligation to pursue cases like this, not only to protect the safety of the people who occupy a piece of property like that, but also for the other citizens of the city who maintain their property and expect the city to go out and enforce its rules. But in that case, at least if you're not completed on the inside, at least get some work done on the outside and make it look like it is, at least progress is being made. Based on the testimony given by the new owners, former owner Mr. Kestenbaum, city staff, and argument made by Ms. Stuparich, I'm going to grant the motion to authorize the city to proceed with a foreclosure action. The amount of the fine will continue to accrue at $250 a day. You may or may not be able to deal with that if the foreclosure action gets filed and you deal with a judge in circuit court. Or if you come back to me, we can deal with it then. But at this point, I don't have the authority to reduce the fine or stop the accrual of the fine. So based on that, I'll enter a written order probably by tomorrow. I'll email it to everybody, authorizing the city to proceed with its foreclosure. Okay? That's my decision. Come on up, ask a question. Go ahead, sir. Yeah.
Again, I would like to ask you, Honor, if in 20 days 4 inspections and CO is not enough. That's one. Second thing is...
Here, let me ask you, what happened between April of 22, since you want to have a conversation,
Yeah,
I'll
of
ask you
course.
a conversation. We'll have a conversation. What happened between April of 22 and September of 24? What was going on in your world with this property then?
To be
It's 2.5 years.
We're here under oath, so I would like to check this. I don't remember by heart
Yeah.
this time of period, but we all know the backstory. We've been
Now, I
here.
don't know the backstory, no.
So again, for this particular 2 years, if you would like, I would like to sit and check on this status. But I know that since the last conversation we had, we follow every rule. If you would told us, or these guys told us, hey, deal with the exterior first, even though all the stucco and paint is done, I will do that.
Yeah. So let me just say to that,
Yeah.
most property owners that deal with investment property, they either know the rules or they hire people who know the rules, and they don't need the city to spoon feed them as to what needs to be done. In your case, you've come up here 2 hearings and basically said, the city needs to tell me what I should be doing. And from my perspective as a code enforcement officer, I don't hear that very often. Most times property owners, especially wise investment property owners who spend 6 figures or 7 figures to buy properties like this with the intent of making money either through continuing ownership and renting it or rehabbing it and flipping it. They usually know exactly what they need to do. So that's why I'm not buying the argument that the city hasn't been able to help you follow what the rules are. I get that there may have been some city staffers in the past who weren't as responsive as you would have liked them to have been. I'm not going to get into that. A lot of times, they are non-responsive. Sometimes it's because of amount of work. Other times because it's either they just slough things off, or they don't have supervision that requires them to be accountable. I'm not saying that either case applies in this particular property. I'm just telling you that, you know, I've heard enough over the last 2 hearings to tell me that the city is entitled to move forward with this foreclosure. Now, you still have to make a business decision as to how you react to that. And I think you and your contractor need to have some serious conversations about getting in there and getting the rehab process going quickly, satisfy the city, and I'm sure you'll have the approval process on permits and getting it completed on one track. You're going to have a foreclosure process that Ms. Stuprich or one of her law partners will handle on another track. And I think your track can go a lot faster than the foreclosure action can go, based on my experience with foreclosure cases. So I think you're going to have time to get this done. You can also make the decision just to walk away from it, too. I'm not telling you to do that. I would go the other direction because you've got a lot of money in this. Mr. Kestenbaum has $86,000 at stake. That's why he flew down here twice to try to protect his money. And I think the only way his money gets protected is if the fine is reduced to something less than $86,000. And I think had there been substantial progress made over the last 4 years, we wouldn't even be here. I think the fact that the property has sat in that condition for 4 years is why we're here. And you've been the owner for that 4-year period, you and your partner. So, my recommendation is you've got some time to get this done, but the clock is ticking a lot faster now than it was clicking before.
Yes, I would also like to mention that in the last hearing, we all said that we want to show us some kind of progress. And we said also that we'll get a CO and all the manpower will shift to 550, which we did. And my statement was and still is, we over-delivered. It sounds like we didn't do much, but we had 4 inspections, even if it's a site thing.
You know what? We've gone through I've heard the 4 inspections,
Yes.
and I've heard, and Ms. Boland, I think, would dispute that there's been actual 4 inspections. I think the site visit yesterday was important. I think had we heard there's a substantial amount of progress being made on the interior, I think at that point I'd be handling this a lot different today. What I heard, though, is that there's not been a lot of progress. And based on that, the city's entitled to an order authorizing foreclosure. How that gets handled, the 3 of you or 4 of you, how many are part of your team at this point, you guys need to make some decisions as to where you're going to go with this.
Yeah, I have
Right.
2 more things just to say. Regarding to what you just said, what is a substantial thing? What to show, like a framing? Think about it. There is.
I'm not you're the big investor.
Yeah,
You're the
no,
contractor.
I would like to.
You should know
okay.
these things,
I-
right?
Which we know.
It sounds like you have investments in Wisconsin,
Yeah.
right?
I will.
You have investments in Florida.
I would like just to finish the sentence. It says,
Go ahead.
the facts are that we finished 600. Corey, we got a CO, so we did deliver. We know what to do, of course.
Yeah.
But also, it's something that we have
So
to
let me
follow
ask,
rules.
why didn't you do 550 and 600 at the same time?
It depends which manpower went to where. We had this in this last hearing. The ice stuff, the hurricanes. We all know that. If you want me to repeat, I can repeat. I don't want to waste your
No,
time.
I've already made my decision. I just,
Of
in
course.
the interest of making sure I hear you out, and if you think I made a mistake, you're going to try to correct me. I don't think I've made a mistake in this case.
I'm not.
I've evaluated the facts the best I can. I've looked at the history of this property going pre-COVID, when Mr. Kestenbaum first invested in the property, and then unfortunately, within a matter of a few months, the world stops because of a disease, a virus that no one ever anticipated. And then he was able to at least salvage some money out of this by selling to you and your partner. But since April of 2022, you've not made the progress the city required. I will give you the benefit of the doubt on the fine when it comes to the 2 hurricanes that blew through this area and devastated the area. I get all of that. I'm just saying that before the hurricane and since then, there's not been the progress made. Maybe on 600, you want to show us that you can do it on 550? Go do it. Now's the time.
And then what? Like my understanding right now. Okay, we're going to complete 550. I'm just saying 3 months. Just throw into the air. Now what? Like, what is it?
Well, I'm going to let you decide with your partners where you go with it. I can't get the crystal ball out and tell you what's going to happen in 3 months, 6 months. You finishing the property in 3 months is hypothetical right now.
I'm just asking what's
Yeah,
the process.
I don't know. I'm not going to answer hypothetical questions. I'm just telling you where we are today, what the ordinance allows me to do, what the state statute allows me to do, what the city has asked for, and the city has positioned itself to be entitled to an order that authorizes the commencement of a foreclosure action. If they get to that point and they take title to the property, at that point, you're going to have to, you're going to have to figure out where you're going to go from there. I mean, you're going to have to battle that out in court if you think if you can defeat a foreclosure action. That's not going to happen here before me.
Okay, and what about the 90 days with the electrical, the red tag itself? Did you check it out?
Your Honor.
I'm not going to.
Because this is the base.
Yeah,
He's
that doesn't.
bordering on asking you for legal advice, and
Yeah.
I have
No,
to.
not a legal advice. This is what you guys are basing on, no?
Okay, you and I are having a conversation. I'm ready to terminate the conversation. I gave you the courtesy of asking
I appreciate
questions
it.
to clarify my order. I think I've clarified it for you.
I just don't
But you're
understand
asking
now
me
what.
about what happens if I can finish this in 90 days. I don't know. I don't know.
Yeah, like now what? What do I do? That's what I'm trying to say.
Yeah.
We're gonna have to keep working with the city, all right?
We
Mr.
terminate-
Webb,
Yeah.
Yeah,
Yeah, I'll let.
that's fine.
So that's what I said last time. I said, let's give this 40-some days where you could meet and come up with a realistic settlement. Didn't see that. I don't know, and again, I'm not ascribing fault to anybody. I'm not saying the contractors dropped the ball, or the owners dropped the ball, or the city dropped the ball. I'm just saying we're right where we were on July 13th without a lot of progress being made. That's why I'm entering the order I'm entering. What happens from here on out, you need to deal with the city on that and decide what your future holds with 550. All right? I believe that's it. We'll close the hearing. Thank you very much. Order to follow by tomorrow. Thank you.